On this week's episode of the Crushing Debt Podcast, 7 myths about Chapter 7 bankruptcy.
Welcome to the Crushing Debt Podcast with your host, Florida attorney Sean Yesner, where our goal is to help you get rid of the financial bullies in your life.
So welcome back to this week's episode of the Crushing Debt Podcast. My name is Sean Yesner, owner and founder of Yesner Law. And so those of you that tuned in last week, you heard that my episode was 13 myths about Chapter 13 bankruptcy. So I thought, what better way to follow that up with 7 myths about Chapter 7 bankruptcy. And again, this all flowed from a conversation that I was having with a client or a potential client that was throwing out all kinds of reasons why they did not want to file a Chapter 13 bankruptcy. And I said to them, well, why do you not want to file a Chapter 13? And every reason they gave me to want to file or not want to file the Chapter 13 ended up being a myth. And so that created last week's episode. If you want to go back and listen to that week's episode, I've got 13 reasons why, or 13 myths about Chapter 13 bankruptcy. But that got me to thinking, there are some myths about Chapter 7 as well, and they're not exactly the same as the myths for Chapter 13. Some of them, spoiler alert, may overlap, but for the most part, they're all different. So I thought I'd do that for you this week. Now, before I really get into the content, again, I want to give a plug, give a thanks to our sponsor, Sam Cohen at Attorneys First Insurance. Sam has been a longtime listener of the show, a longtime supporter of the show. We appreciate all of his great feedback, and one of the ways that we want to support him in terms of his sponsorship of the show is we want to refer him attorneys and title companies that need malpractice insurance or that need professional liability insurance. Same thing. So if you know an attorney or a title company, whether it be in the state of Florida or the state of Texas or anywhere in the country that needs to renew his or her malpractice policy, please refer them over to Sam Cohen. They can reach Sam at sam@attorneysfirst.com or www.attorneysfirst.com. And so, again, that would be a great way to show our support for somebody that gives a great amount of support financially and otherwise to the Crushing Debt Podcast. So thanks again, Sam. But I wanted to talk again this week about the 7 myths of filing a Chapter 7 bankruptcy case. Now, for those of you that don't know, a Chapter 13 is a reorganization type. It's a payment plan type bankruptcy where we're making payments to the bankruptcy trustee based on income or based on non-exempt assets to repay creditors some percentage of what that's owed. I've seen Chapter 13 cases that are low as single-digit percentage return to the creditors, and I've seen them as high as 100% return to the creditors. But that's what a Chapter 13 is. A Chapter 7 is a liquidation. So in a Chapter 7 case, we are liquidating assets and using the value, using the money created from those liquidated assets to pay back creditors. Now, in a perfect Chapter 7 scenario, there would be exemptions that protect all of the debtor's assets, and so there would be no money owed to the creditors in a Chapter 7 case. And so that would be the best case scenario. And again, some of these myths I'll go over where some of that may differ. But let me jump into myth number 1 here, is that any money you earn after filing belongs to the bankruptcy trustee. Now, one thing that I like to describe is that a Chapter 13 case is fluid. It can change. I talked last week about tax refunds and about presenting your tax returns to the trustee every year. Chapter 13s are fluid, but contrast that with a Chapter 7, which is basically just a snapshot in time. And so if you make money after filing the Chapter 7, that is your money to keep. The trustee's not necessarily going to go over that money, with some limitations to that. Now, the Bankruptcy Code does say that inheritances that are that you're eligible to receive within 6 months of filing, before or after, belong to the bankruptcy estate. So if you have a relative that dies within 6 months after filing the bankruptcy case and that relative has left you an inheritance, whether you've received it or not, it does belong to the bankruptcy estate. If it's money that you're entitled to receive but don't receive until after filing, it may be entitled to the bankruptcy estate. For example, you're entitled to some kind of large personal injury judgment from an accident that happened prior to filing the case. Well, if you receive that personal injury judgment after filing the case, it's going to belong to the bankruptcy trustee. But if you file a Chapter 7 bankruptcy and then you get a raise at work, you find a better paying job, you start your own business and it takes off, any of these situations, you can keep that money as long as it's after filing, as long as all this stuff happens to you after filing. Great example of that. I had a client who was a bookkeeper and had her own bookkeeping business and ended up filing Chapter 7. Well, a few months after the Chapter 7 was over, her bookkeeping business exploded. She got more clients. She got more bookkeeping appointments. She got a lot of revenue, and her business exploded. And that was all hers to keep because it all happened after the case was filed, and in this case, after the case was over. But that's the first myth about filing Chapter 7, is that you cannot earn any money after filing, and that is, for all the reasons I just talked about, that's a myth. The second myth here about Chapter 7 is the trustee will take all of my stuff. Now again, the reason that I have this one as a myth is because, like I said, the trustee can only take assets that are not exempt. If your assets are all exempt, if your assets are all protected, then this is a myth. The trustee cannot take any assets away from you. I had a consultation with a client just prior to recording this episode, and she lived in a furnished apartment, and she did not own a home. She did not own a business. She did not own any expensive jewelry. She did not own a car. She didn't own outright any assets of significant value. And in a situation like that, in Florida, you get to exempt or protect up to $5,000 worth of stuff. And so the value of all of her stuff is clearly less than $5,000, and so she can protect it all. So the bankruptcy trustee will not come in and take all of her stuff because it's all exempt and it's all protected. Now, myth number 3, sort of similar to myth number 2, the trustee will come into my house and examine all my assets. Now, I put this one down as a myth because in the majority of my cases, it does not happen. Now, I have had situations where the trustee has sent an inspector or an appraiser, probably an appraiser, into the home to determine the value and determine the accuracy of what we listed in the bankruptcy schedules. But I try to do a pretty thorough job of going over the assets with the debtor to try to, before we file the case, to try to avoid some of these inspection situations. I try to look for the red flags that I think the trustee is going to see, and I try to sidestep some of this stuff. Things like, if you live in a 1,500 square foot home, but you list that you have $100 worth of stuff, that's going to draw the trustee's attention and may create a situation where they want to inspect or appraise the property. And the reverse is true. If you live in a $2,000 square foot home, and you list that you've got $10,000 worth of stuff in the house, the trustee may want to come in and take a look and see what you got. Now, I'm not saying lie about the value of your stuff, but what I'm saying is a lot of times people don't necessarily have an accurate value of the stuff that they own. And so if we can make those values as accurate as possible, a lot of times we can avoid the trustee sending an appraiser into the house. Now, again, I'm not 100%. I have had some cases where the trustee has sent in an appraiser. But the reason that I put number 3 here, that the trustee will come into my house and look at my stuff, the reason that I put this as a myth is because if you're working with the right bankruptcy attorney, and if you're listing your assets honestly, and you're listing their values to the best of your knowledge, then the chances of an appraiser coming in are pretty low in my experience. And so for that reason, I've listed it as a myth because it doesn't happen very often in the cases that I file. Myth number 4 here, I will lose my house. Now again, I did talk about this one a little bit in the Chapter 13 episode last week. Florida has one of the best homestead protections, one of the best homestead exemptions in the country. Now, to go along with that, we have sort of some of the worst personal property exemptions. But if you own your house and you're current on your payments, or even if you own it outright, the trustee cannot take your house away in Florida. Now, there are a couple of caveats there as well. If you've used non-exempt assets, so you got a big personal injury settlement and you use that to pay off your house, there may be a scenario where the bankruptcy code, even if you're in Florida, does limit the homestead exemption in a situation like that. I can tell you in my 20-something years of practicing in bankruptcy law, I've never seen that happen. Since this rule was amended in the amendments in 2005, I've never seen it happen personally, which is why I've called it a myth. But if you want to keep your house and you file bankruptcy, you just need to continue to pay for your house. And you can keep it in the bankruptcy, and the trustee cannot and will not take it from you if you're in Florida. Now, if you're not in Florida, check with a local attorney, because there are some states that do not have an unlimited homestead exemption like Florida has. And so if you're in a state that limits the homestead exemption, it's possible that your house could be taken to pay your creditors in a bankruptcy case. So if you're inside the state of Florida and you've got equity in your house, you are probably, most likely, more often than not, you're protected. If you live outside the state of Florida, you need to talk to a bankruptcy attorney, and you need to make sure what the laws are in your area, in your state, to make sure that you can protect your homestead. Number 5, and I don't know, I have this in my notes written as a hardship. I don't quite know how to describe it, but the situation goes something like this. The person in bankruptcy comes to me and says, "But you don't understand. The trustee doesn't understand. I need my car to drive to work. If I don't have my car, I can't make any money. You don't understand. If the trustee requires that I pay this money based on the value of my non-exempt assets, I won't have any money left over. How am I supposed to pay for X if I'm in bankruptcy?" In other words, the person in bankruptcy is trying to give me some hardship reason why the bankruptcy code should not apply to them. And the myth here is that hardships apply in bankruptcy. They do not. Now, maybe from time to time, there's always an exception to the rule. But this is how I describe it to my clients. I say, look, the minute that we try to claim a hardship to the bankruptcy judge, to the bankruptcy trustee, they're going to turn around and say, while we understand and while we sympathize with your hardship, know that your creditors are also suffering a pretty big hardship. That is the elimination of the debt that you owe them. And so a lot of times the bankruptcy judge and the bankruptcy trustee will argue that the hardship to the creditors is greater than any hardship that you might experience. So, for example, a car that is worth $10,000 that's free and clear. Well, Florida only gives you a $1,000 exemption. And even if you do not own a home and you use the wild card $5,000 exemption, that still leaves $4,000 of non-exempt value in that car. And so the trustee is going to say, give me $4,000 or give me the car. Now, if you turn around and you say, well, obviously, if I had $4,000, I wouldn't be in bankruptcy. So, and I can't pay this $4,000. And I need my car to drive to work so that I can make money, so that I can pay my bills. And so I have a hardship here. Well, again, that's not going to apply. In other words, the judge and the trustee are basically going to point the finger at me and say, well, your bankruptcy attorney should have explained this to you prior to filing bankruptcy. And so these are some of the issues that I try to flesh out as we go through the due diligence process to put together your bankruptcy petition. And so the myth here is that hardships will apply to the debtor, where more often than not they won't. Now, again, I don't want to make a blanket statement. Judges are human. Trustees are human. Everybody's situation is a little bit different. But in the majority of cases, if you walk into bankruptcy court and you say, I need XYZ to happen, otherwise I'm going to suffer a hardship, very, very few scenarios where the judge and the trustee are going to agree with you on your analysis. So if you're filing bankruptcy for the relatively short period of time you're in bankruptcy, forget about hardships. Just try to make it work. Try to make it happen. Another myth that I see a lot is that Chapter 7 is harder to file. Now, again, harder to file, I don't know if that means more difficult to file. I don't know if that means harder to qualify for. I don't know how that differs from maybe, a Chapter 7 being more difficult or less difficult than a Chapter 13. But again, I think this is a myth. I file plenty of Chapter 7 cases for a client, and they all come down to the very same types of issues. What is your income, and is your income below the median income such that you can file a Chapter 7? If your median is above the median income, what expenses do you have that we can use to reduce your income and qualify you for a Chapter 7? If you meet those two tests or one of those two tests, can we exempt or protect your assets, or can you pay the trustee for the value of those assets? That's it. That's really all it takes to file bankruptcy. The rest of it is, where do we put it on the schedules? Where do we put it in the particular buckets? But at its core, what's your income? What are your assets? And that determines if you can file a Chapter 7 or a Chapter 13. Now, the 2005 amendments, BAPSIPA, the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005, I think was designed to make bankruptcy more difficult to file. I think it was designed to put more barriers to entry to the bankruptcy court. But at the same time, bankruptcies have hit record numbers in previous years. Now, bankruptcies have dropped recently, but I have a feeling with the expiration of the eviction and foreclosure moratorium, bankruptcies are about to increase again as more people seek to protect their homes or stay in their homes longer or eliminate maybe debt that they would owe their landlord or their bank. I have a feeling bankruptcies are going to tick up here in the near future, but bankruptcies are not really that hard to file. It was an adjustment period in 2005, 6, 7. It was a little bit of an adjustment period as we got used to the new rules, and still there's new case law coming out every day about the bankruptcy code. Congress is looking at changing the bankruptcy code, so things are still fluid, things are still in motion. But in my opinion, a Chapter 7 is no more difficult, no harder to file, really, than it ever has been or than a Chapter 13 would be. The last myth that I have here is that my credit is destroyed. And I think for the same reasons I talked about in last week's episode about Chapter 13s, I think this is a myth as well. It is my understanding that within 7 years of a Chapter 7 filing, the bankruptcy will drop off your credit. And within 10 years of a Chapter 13 filing, the bankruptcy will drop off your credit report. However, the impact of the Chapter 7 or Chapter 13 will only be felt for 2 or 3 years. Again, that example I brought up at the beginning about my client that had her bookkeeping business take off. She was able to buy a house with her husband on a golf course, about $300,000 at the time, within, I think, 3 years of filing, maybe 2 years of filing the bankruptcy. So credit is impacted. There's no way around that. However, like I said in the Chapter 13 myth, a lot of the things that cause people to file bankruptcy are going to hit your credit anyway. So the fact that you file bankruptcy isn't any greater hit on your credit than what caused you to file the bankruptcy in the first place, in most cases. Plus, your credit will recover within a few years. The impact of the bankruptcy will lessen. And then again, after 7 years, it falls off your credit. So like I said in last week's episode, here we are in 2021. Where were you 7 years ago? Where were you in 2014? If you had been discharged from a bankruptcy in 2014, it would be off your credit report at some point this year. So, time as a relative measurement does go fairly quickly. So those are my 7 myths. Now, as I was brainstorming and researching and preparing for today's episode, I want to give you a bonus myth. So I don't want to call it myth number 8 because the title is 7 Myths About Chapter 7 Bankruptcy. But I want to give you a bonus myth, and that is that you have to have a minimum amount of debt in order to file bankruptcy. And again, I think that's a myth for a couple of reasons. First, I think in order to file bankruptcy, you only have to have more debt than you can afford to comfortably repay. And so, again, I talked to somebody today who has about $30,000 of debt, but makes about $45,000 a year. That's more than they can afford to pay. But if you took somebody with $30,000 of debt that makes $300,000 a year, then maybe bankruptcy is inappropriate for them. And again, if you have somebody with $300,000 of debt, but they make $3 million a year, then again, it's probably something that they can handle in a reasonable period of time. So, and again, like I talked about in some of the earlier myths, bankruptcy is based on your income. Bankruptcy is based on your assets. I didn't say bankruptcy was based on the amount of your debt. Now, there are certain debt limits that we have to look at, especially if you're looking at filing a Chapter 13. There are limits to the amount of debt that you can have as secured or unsecured, but those limits are fairly high. And I think only once or twice I bumped into somebody that exceeded those debt limits. And in that scenario, Chapter 7 would work, Chapter 11 individually might work. But again, I think it's a myth that you have to have a certain amount of debt in order to qualify for any form of bankruptcy. I think you just have to have more debt than you can reasonably afford to repay. And again, how much debt do you have is not as relevant as what is your income and what are your assets. So that'll do it for all of the myths that I know about Chapter 7. Did I miss any? If I did, what are they? Let me know. Email me, Sean@yesnerlaw.com, and we'll certainly bring them up in future episodes. But again, our 7 myths here. Number 1, you can't earn any money after filing. That's false. Number 2, the trustee takes all my stuff. Not necessarily, and in the majority of cases, that is untrue. The trustee will come into my house. Again, they can, but it doesn't happen very often. And if you have the right bankruptcy attorney doing the right due diligence, it shouldn't happen very often. Number 4, I will lose my home. Again, as long as you keep paying for it, that is a myth. Number 5, I have a hardship. Again, we don't talk about hardships, or I don't talk about hardships in bankruptcy cases because the creditors also have a fairly significant hardship. Myth number 6, Chapter 7 is harder to file. I don't believe that to be true. Number 7, my credit is destroyed. Well, it may be anyway prior to the filing. And then our bonus myth, you have to have a minimum amount of debt in order to file Chapter 7. So that's all that I have for this week's episode. Again, did I miss any? Did you not understand any? Are there any that I could explain or expand on in more detail? But at least for this week's episode, a shorter episode, and I will be back next week with another topic. But in the meantime, I hope that you have more money at the end of the month rather than more month at the end of the money. That'll do it for this week's episode, and I look forward to talking to you in next week's episode of the Crushing Debt Podcast.
If you have questions that you think would make a great topic for a future episode, please email Sean or connect with us on social media. Sean Yesner and Yesner Law, PL, are Florida licensed attorneys. The information contained in this week's episode is not a substitute for legal advice. Your situation may differ, especially if you are located somewhere other than the state of Florida. If you have questions, please contact our office or contact a local attorney. Thank you for listening to this week's episode of the Crushing Debt Podcast.